Hi, my name is David Coher, and I'm an attorney with the California State Bar, and I am here to talk about cybersecurity principles for attorneys. First, let's talk about the legal and ethical obligations that we have as attorneys. As you know, there is a duty of confidentiality required of all attorneys with client information. That information can come by any manner of the representation, whether it's through an initial consultation when a client's considering hiring you as their attorney, through the representation in negotiations for a transaction, litigation, or otherwise. That information both has evidentiary protections, such as the attorney-client privilege and the attorney work product protections. However, those protections relate to the use of that information as evidence in court. In addition to that is the much broader duty of confidentiality. The specifics of the duty stem from California Rules of Professional Conduct, in particular 3-100, which states that you as an attorney have an obligation to keep your client's confidences. That Rule of Professional Conduct relates back to Business and Professions Code 6068, which details the information that must be kept confidential. The question here today is about how do you keep that information confidential when it's in an electronic form, either primarily in email communication or in a data file such as a Word or Excel document. There is some guidance on this. In particular, the ABA has issued a formal opinion, 11-459, which you can read online. That opinion is based off of the model rules and not necessarily the California rules. However, it does give us good guidance in terms of what to be doing. One of the key takeaways from that formal opinion for me was that there is a notification due to your clients regarding the potential confidentiality issues present when using email or data files over services such as the cloud. How that notification is delivered to the client is not specified. One option might be in the retainer agreement itself. Another might be to discuss it with your client in person, or perhaps you could put it in the signature line of your emails. All are valid options. And really, what's going to be appropriate is going to be dependent upon your practice, upon the client, and quite frankly, the particulars of the case or negotiations representation that you're having for your client. That is to say that some confidential information is more confidential than other information. In addition, the State Bar has issued a formal opinion on this. That was 2010-179. That formal opinion includes a 6-part test for attorneys to review and analyze whether or not there is a greater or lesser duty of confidentiality in terms of the handling the electronic form of the confidential information. That is to say, whether you have to take extra steps or not is going to be dependent upon the nature of the information, the nature of the representation, and also, quite frankly, how valuable it's going to be to your clients, business partners, adversaries, or others. Now, once we've analyzed the privilege, the duty of confidentiality, and determined that we do need to take some steps to protect that confidentiality, we then hit upon the duty of competency, which is also covered in the Rules of Professional Responsibility, in particular, Rule 3-110. While the rules do not specifically require that you have knowledge of technology, the comments of the California rules, which are based upon comments from the ABA's model rules, do indicate that that is a reasonable expectation for competent representation. I think especially for us as new or recently admitted attorneys, we should be looking at these issues with regards to our experience with technology. That is to say that it's not required that one be an expert on cybersecurity or a cryptographer in order to protect their clients' protected information, but it is reasonable to take additional steps to learn about the technologies that are available. And with that, I'd like to talk a little bit about what's available out there and the steps that we can reasonably take to protect clients' confidential information and, quite frankly, our own information. So one of the first things that we can do is to be sure to use unique passwords. Now, I'm sure that you've heard this regularly and often, but some things that we can think about doing is to avoid using words. A lot of the tools that are out there for cracking passwords are going to rely upon dictionaries as a source of words to try to test your password. So using common words in your password is going to set yourself up as prone to those types of attacks. Another common trick is to put numbers at the end of the password. However, the folks who may be trying to infiltrate your system also are aware of this. So put those numbers somewhere else in the password. Two-factor authentication is an excellent way to protect your information and your client's information. What two-factor authentication is requiring that you have another device with you, not just the password. Many services such as Yahoo Mail, Gmail, Dropbox, and the like do have settings that allow you to set up your email with a password, or the service with a password, and then require a text message with a code to your cell phone that must be entered into any new computer, tablet, or other phone that you're trying to access the service with. By doing this, it requires that anybody who's infiltrating your data will not only have to guess at your password, but will have to obtain your phone as well. Another key step to take is to update our software regularly. The software updates that are issued by vendors, whether those be for the operating systems, for particular applications, or otherwise, are usually designed to address security vulnerabilities as they are discovered. It's impossible, quite frankly, for us to be on top of every security vulnerability, and you would never have time to advise your clients. So instead, simply rely upon the software providers to provide you that service by updating your software regularly, taking advantage of their security practices. Something else you can do, turn off the automatic download of pictures or attachments from your emails. Oftentimes, this is how malware will seep into a system. It will be coming in through a picture that has some type of extra code attached to it. The way to protect yourself against that is to simply turn that off. This is a common setting in most email clients, whether that be through your web browser or Outlook or otherwise. And then be sure to use secure connections whenever possible. That means when you're on the web, using HTTPS before a web address instead of simply HTTP. Finally, I'd like to suggest to try to use your own equipment. I, for example, have a personal hotspot that I carry with me rather than using free Wi-Fi. It means that I have control over who is handling that data between myself and whomever I'm sending it to or accessing it from. With these kinds of steps in place, you should be able to protect yourself against most of the more easy hacks that could be out there. This doesn't mean, of course, that you're entirely protected, and how much protection you're going to take steps to take is going to be dependent, again, on the type of information you have and your clients. I would advise speaking with your clients about the matter to the amount that is appropriate, dependent upon the circumstances of your representation. However, I found that many folks are very appreciative when they learn that these are issues that we have visited, discussed, and thought about ahead of time. And with that, I'd like to thank you for your time and invite you to contact the State Bar if you do have further questions by the information available on the website. Have a great day.